Okay. So, good afternoon to all. I welcome you all to this webinar, workshop webinar conducted by ICSI IIP. At the outset, I thank ICSI IIP for their invitation. I also thank you for your participation. So, let me share my presentation. Just- Is it visible? Hello, it is visible? The presentation is visible to you?
Yes, sir. Yes, sir. It is visible, sir.
Okay, thank you. So, friends, today our topic is interplay of IBC with FEMA. I'm sure you are aware or you heard about the East to Do Business Index. This index was published by World Bank. I think now they have stopped it. Last the index published by them was in the year 2022. Anyway, the ease of doing business indicates the investment friendly location where the investors can put their money. They are based on certain parameters as determined by the World Bank. And friends, when the index was last published by World Bank, India consolidated its position significantly. I think India improved its position from 149th to 43rd. There is a big jump in the list. So what indicates that India economy is a industry friendly or entrepreneur friendly, provided various opportunities to the investors to put their money in the economy. So this is possible, friends, because in the recent past, Government of India has introduced certain beautiful legislation statutes to name firstly the GST, then amendment in the Arbitration and Reconciliation Act, amendment in the Competition Act. Then also our Companies Act undergone certain changes which are really industry friendly. And importantly, Government of India has introduced Insolvency and Business Bankruptcy Code in the year 2016 to address the ease of doing business. I'm sure you will appreciate. And basically, this code was introduced to address the insolvency resolution process of an entity. And you will appreciate that it is not always the malified intention or wrongdoing of the promoters or the management, because of which an entity goes into the insolvency, becomes financial insolvent. But there are some genuine reasons also. For example, maybe some new development, new regulation brought in within the country by the government, by which the running of business becomes unviable. I can take one example that during COVID time, you know that many company under the hospitality sectors gone into come under the purview of CIRP, Corporate Insolvency Resolution Process. This is mainly because that the restriction in traveling, which was put across the globe. And you know that generally the hospitality sector, they depends upon the main business, I mean, parameters for them is the tourism. So anyway, this IBC was introduced in the year 2016 to address the corporate insolvency resolution process. And another thing I must say that, look, ease to do business also requires ease to exit. Just now I said that it is not always the malified intention. So when there is a genuine cause, the opportunity should be provided to the entrepreneurs to come out from the business, come out from his business, so that he can save his money, which he has put into the operation of the entity or business, you can say. So IBC also provides the ease to exit by providing various provisions within the code. So, okay, these are not our subject matter for discussion. I just want to know I just want to tell you that the importance of IBC and the change in economic scenario after the introduction of IBC within the country. Friend, interplay, this particular word, you will not find anyone, at least not in code, and it is not also take place in any statute or laws, nor even the General Clauses Act incorporate the definition of interplay. So if you take the dictionary meaning, the definition given in the dictionary for interplay, we will see that interplay means how two things affect each other when they come into existence together. So interplay of IBC with FEMA, it indicates how when a scenario comes where the proportions of both IBC and FEMA will be applicable, how the things will be done or how it will be addressed based on the provisions given in IBC and the FEMA. And we will discuss more details in the subsequent slides. So let's start. Only one request I have. Please make it an interactive session. Don't make it a monologue type of thing. Whenever you have question, please ask me. Maybe I'll be able to learn from you. Many things. I have no hesitation to say that many things may be also not known to me at present. But I expect that after this webinar session, we will share our knowledge and we will sharpen our knowledge base through the interaction. So, friend, my request to you, please interact. Please make it an interactive session. Okay. It is visible, no? I think it is visible, the presentation. So initially there are some disclaimer from my side, like that the views expressed here is purely my personal view, so can be interpreted or viewed differently by other persons. And in any case of legal matter, I request you kindly take the opinion of your legal counsel. Okay. So, friend, in order to understand the interplay of IBC with FEMA, not only FEMA, in that sense, with all each and every. With each and every act or statutes, we should see the objective for which the IBC was brought into the picture. So as I said that in the year 2016, Government of India introduced this code to address the insolvency resolution process within the country. But does it mean that prior to this, there was no such code or no such statute available within the country? No. In fact, there were several statutes or laws or acts available But like, for example, SICA, Sikh Industry Companies Act, then your Provincial Insolvency Act, Presidency Town Insolvency Act, even SARFAESI Act, even our Companies Act also deals with the winding up of the companies in certain scenarios, circumstances. But the main problem with all these things that these statutes operates in a staggered way. They are not complementary to each other. They are for the particular purpose. Each of them was devised for a particular purpose. Like SICA was for the Sikh industrial companies, units or companies. Provincial Insolvency Act is for the personal insolvency. So as a result of which the resolution process becomes a long drawn process. And you will appreciate that if a legal process becomes a long drawn one, the cost involvement also increases. So in the earlier situations or scenarios, the cost is involvement is absolutely not, I mean, what should I say? It's not desirable. It was a costly affairs for the insolvency resolution. That's why in order to address these things, Government of India brought this code as a consolidated law. Now, each type of organization, each type of entities are now addressed by IBC. Now, there is only a single law or code to address the insolvency resolution process within the country. And the objective of IBC is, it is a time-bound, it should be done in a time-bound manner for the maximization of value of assets of such persons, promote entrepreneurship, availability of credit, balance of interest of all the stakeholders. Friends, today our discussion, interplay of IBC with FEMA, purely based on the objective of IBC for maximization of value of assets. We'll discuss in detail subsequently, but this particular object is addressed through the interplay of IBC with FEMA. Not only FEMA, with any and each and every act or statute. So this is the objective of IBC, and for this objective, IBC is given a very unique proposition. Unlike earlier laws or statutes which are addressing the insolvency matters, IBC now become a consolidated law, a single law in the country. Sorry. It address the issue on a time-bound process. I think this is the first time in an act where the timeline is specified within the code, within the body of the code itself. It also looks for the maximization of asset values, promote entrepreneurship, because IBC operates in two phases. First is the revival, and if not possible, then liquidation. So initial interest out of this code is to promote entrepreneurship. New person comes and take over the financially distressed company. Credit availability, balancing of interest. Friends, you will appreciate or you will agree with me that the foreign investment is one of the key determining factors of economic growth of a country. I think in the developed countries, Germany, I can tell you that in fact, 80% of its production goes out of the country. I mean, selling goods or investing money, all are comes under the foreign investment. So it is key determining factors for the economic growth. Not only that, the country which is receiving this foreign investment also flourishes in its economic activity. And jurisprudence determine the interplay of IBC with the borrowing routes of the foreign investments, which is addressed by FEMA. So borrowing routes for investments, which is addressed by FEMA, various case laws are there to determine how IBC will affect those borrowings which are taken by the organization within the country. The interplay of IBC and FEMA comes for dealing with the transactions across the territories during the insolvency proceedings. For example, when a corporate debtor undergoing insolvency process has foreign creditors or assets outside the country, FEMA regulations would need to be considered to ensure necessary compliance with foreign exchange rules. So whenever a company has foreign assets or its assets located in foreign country, or it has taken money, or it has the not only money, its services also, it has the foreign creditors, you agree that at that time, dealing with these things, the FEMA provisions of FEMA will come into picture. Further, the outcome of CIRP through resolution plan may impact FDI or ECB arrangement by restructuring or settling these debts. As just now I told you that first of all, it is the revival. The first step for IBC, under IBC for resolution, is to revival the company. So you know what's happened. I think all of, I mean, it is, you are aware that RP, IRP, RP, they ask for the resolution plan for this purpose to revive the company. And the person who submit this plan are called resolution applicant. Now, this resolution applicant, they may source the funds through foreign direct investment or external commercial borrowings to pay the debts of the distressed company. And that time, at that moment of time, at that moment, the provisions of FEMA will come into place. So IBC, when the resolution of the company, under IBC, when the resolution of the company is taking place, then also the matters, scenarios may arise which are governed by the provisions of FEMA. But IBC has supremacy over FEMA as established by IBC section 238. We will discuss in detail later. Because you know, IBC, that's why I said that IBC was introduced by the government to address the insolvency resolution process, but more so, it was developed for ease of doing, as a business friendly code or statute. So it contains a section, non-obstantive section 238, which has provided the overriding power to this code. So friends, there are many jurisprudence, many case laws are there, which also admit the supremacy of IBC over not only FEMA, or any other statute in that sense. Because of this section 238, which grants it an overriding effect. As such, IBC's moratorium, another provision is incorporated within the IBC, that is moratorium. We'll also discuss these things. which freezes a corporate debtor's assets during insolvency proceedings, prevails over FEMA's power to seize or attach those assets. I think all of you know that under Section 37A of FEMA, the Act provides the power to the ED, Enforcement Directorate, to seize the assets if there is any violation of the foreign exchange procedures. But because of this moratorium, particular provision of moratorium within the code, that also, what should I say? That also can be challenged in the IBC proceedings. When a company comes under the purview of IBC or under the purview of CIRP, that particular power granted by FEMA can also be challenged, preventing enforcement of FEMA actions against the company's assets during CIRP. This principle protects the company's debtors' estate and ensures that all creditor shares in the full assets. That's now we saw in the objective clause of IBC that it addressed the interest of all the stakeholders. So the government, with this intention, government has put sufficient provisions within the code to address that particular point, objective point. FEMA regulates foreign exchange and investments in India, and its provisions may involve actions like asset seizures. However, Section 238 of IBC contains a just now we talked about a non-obstantive clause stating that the provisions of the code shall have effect, notwithstanding anything inconsistent in any other law for the time being in force. According to the moratorium under IBC, another provision we just now discussed, when a corporate insolvency process begins under the IBC, a moratorium is imposed, which prohibits the seizure or attachment of the company's assets. I'm sure all of you know that when an application is filed with the adjudicating authority, that is NCLT, that particular date is called the initiation date. So after the application is filed and recorded by the registry, then hearings going on. Both the parties are given the opportunity to put their views on the particular issues. So when the application is accepted or admitted by the adjudicating authority, that date is called the commencement date, insolvency commencement date. So first one is the initiation date, second one is the commencement date. And when the adjudicating authority passes the order by admitting that application, in the same order, the adjudicating authority also declared the moratorium for the corporate debtor. And this is as per the provision of the code. We'll see it later. So, once the moratorium is imposed, then the assets which are owned by the debt cannot be taken out. Other points are also there, but main thing, what I mean to say that the assets cannot be taken, the corporate debtor cannot be taken. Here, moratorium under IBC has been upheld by courts to overrule conflicting provisions in FEMA. Friends, I am writing this FEMA, but please take note of it that not only FEMA, this is applicable for each and every act or statute. This means even if FEMA requires an asset seizure, the IBC's moratorium protects the asset. The primary purpose of this supremacy is to safeguard the corporate debtor's asset during the insolvency process, preventing them from being fragmented or attached by individual creditors or regulatory bodies. This is also as per the objective to take into account the interest of all the stakeholders. So the legislature ensures that the asset of the corporate should not be taken out by any individual or the regulatory body. However, IBC's overriding effect generally applies to the corporate debtor assets. Actions against individual directors or officers for their personal liability may still be permissible even during moratorium. The only thing we have to keep in mind that this moratorium, the effect of this moratorium or this overriding provision of IBC is only for the matters related to the corporate debtor. It will not give any immunity to its directors or any persons in the helm of the management of the corporate debtor if there is any violation done by him. So personal liability. So personal liabilities are not covered under the provisions of IBC. In summary, during insolvency resolution process, the IBC creates a unified legal framework that prioritizes the orderly resolution of the company's financial affairs, effectively superseding FEMA's enforcement actions against the debtor's estate. So the main purpose through IBC is to consolidate, to maintain the status quo. Consolidate the position means that to maintain the status quo for the corporate debtors so that proper resolution can be taken, can be brought by the resolution profession. The CIP and the subsequent liquidation process presents an unique opportunity for foreign investors to acquire a distressed Indian company or its assets. Because of these provisions of IBC and because of its what should I say, overriding effect over the other acts, it also, that's why I'm saying the ease of doing business. It also provides the opportunity for the, sorry. It provides the opportunity to the foreign investors to acquire by bringing the foreign investments to acquire the distressed Indian company. So IBC also facilitates the foreign investors to put their money for acquiring the distressed companies within the country. FEMA and regulations frame they are under and the FDI policy do not prescribe a special or a separate regime for making investments in distressed economies undergoing the corporate insolvency. So there is absolutely no separate chapter or what should I say, separate rules and regulations for doing these things, for bringing foreign money to purchase the distressed company. It will be done within the same framework or same rules and regulation of FEMA. Therefore, a foreign investor seeking to acquire or make investment in a distressed company undergoing the CIRP or in liquidation is required to comply with various procedural and other requirements under the FDI laws, in addition to complying with the requirements under the code. So the same process they are to be followed if they bring their money otherwise for a solvent company. There is no extra compliance or extra workload for the foreign entities if they want to purchase the distressed Indian company. And friends, you will appreciate that. I mean, definitely, I mean, it is a very profitable proposition for the foreign investors to what are distress, because of this is distress issues or financial insolvency, they can purchase this company at a very competitive price than for a normal company, isn't it? So there also IBC really helps to bring the foreign investments which are controlled through FEMA to grow the country's economy. So please, if you have any question, ask me. Now we'll discuss two very important provisions in IBC, which really provides the supremacy of this code over any other actor. I have already told you that first one is the moratorium, provision of moratorium incorporated within this code, and second is the provisions of section 238, which is an non-obstantive clause with overriding power, provides the overriding power to this code. Friends, again, the term moratorium has not been defined in the IBC. So again, if we go to the dictionary meaning of moratorium, it says the moratorium indicates a stopping of an activity for an agreed amount of time. Some activities are stopped for an agreed amount of time, not for indefinitely, but for certain period of time that particular activity should be stopped. And that moratorium means. Therefore, the moratorium under IBC 2016 can be constructed as a temporary suspension of an activity or law until future consideration warrants lifting the suspension, such as if and when the issues that led to moratorium have been resolved. I have already told you that when the adjudicating authority passes the order accepting the application filed against the corporate debtor, be it under section 7 or under section 9 or section 10 also, at the same order, the adjudicating authority imposed the moratorium for the corporate debtor. And unless and until the resolution is done, either through resolution plan or through the order of liquidation, this particular moratorium will continue. The suspension of certain, debarring certain actions against the corporate debtors will continue until that time. Moratorium under IBC 2016 is a period wherein no judicial proceedings for recovery, enforcement of security interest, sale or transfer of assets, termination of essential service contracts can be instituted or continued against the entity under insolvency resolution process. So under resolution process, no judicial proceedings for recovery. So whether it is PLMA, but okay, I mean, I'll not go for a detailed discussion. There are certain jurisprudence where it is said that, okay, PLMA can have the effect because they are not, both the purpose of PLMA and IBC are different. So, okay, I am not discussing all these things. But generally, the judicial proceedings for recovery, enforcement of security in the sale of transfer of assets, all these things are stopped against the corporate debtor. The adjudicating authority, that is NCLT, declares the moratorium period. It also mentioned that from where it is start. It is generally start from the insolvency commencement date. The main purpose of declaring such moratorium period is to keep the assets of the entity intact, which otherwise may be attached by any competent court of law during the pendency of insolvency proceedings. So in order to stop any attachment, whether it is FEMA or any other cycle, this moratorium will be imposed and these particular provisions in the code will take care of it. The idea of moratorium is that to facilitate the continued operation of the entity under insolvency resolution process, to allow it breathing space to organize its affairs so that it may be out of the instant situation and thus benefit all stakeholders in the process. So the main purpose is to provide a breathing time. Breathing time means that the IRP or RP should be able to discharge their functions undisturbed, without being disturbed. If cases are filed against the corporate debtor, if the enforcement decrees are passed, then it will be very difficult for them to find out the resolution for the corporate debtor. Because he will be busy with addressing these things. He will be busy with, moving from court to court. So in order to address these things, this moratorium is imposed. Or maybe, I should say that this particular provision is incorporated within the code. In the matter of Power Grid Corporation of India Limited versus Jyoti Structures Limited, the Delhi High Court held that the object of the IBC is to ensure that the corporate debtor receives relief during the standstill period. Standstill period, the period during which the resolution is going on, protecting its assets from being diminished and alternatively using this period to strengthen its financial positions, as the IBC 2016 is intended to prohibit debt recovery actions against the assets of the corporate debtor. One thing I am sure all of you know, that it is very much clarified by various jurisprudence. Also, I think MCA also clarified after introduction of IBC by stating that IBC is not for debt recovery. practically we see something else. Sometimes we see something else, but that is not the main intention of the legislation. And that's why I said that this is because the introduction of the code, the position of the country of India has improved significantly towards the ease of doing business. Because this particular code introduced by the government of India mainly to address for the resolution of the distressed position of the company, not for recovery. So one of the goals of having an insolvency law is to ensure the suspension of debt collection actions. This is the main, I mean, what should I say, the major objective of the, or major intention of the government for introduction of this code. Suspension of debt collection actions by the creditors and provide time for the debtors and creditors to renegotiate their contract. All of us are aware of provision of Section 12. Many cases we have seen where the settlement is done. So if the person who has given the charge for running the company during this resolution time, if he is busy with all these activities, then he can renegotiate, or he can perform these actions anyway, isn't it? This requires a moratorium period in which there is no collection or other action by the creditors against debtors. Moratorium is applicable to all proceedings which have a civil nature or seem to enforce a civil remedy. The basis for the application of moratorium is the nature of such proceedings and the object and purpose of such enactment. Friends, IBC only addresses the issues which are civil in nature. You know that there are two types of things, litigations. One is civil litigations, another is criminal litigation. So criminal litigations are not under the purview of IBC. For example, if there is any fraud or if there is any cheating, which are governed by the criminal laws of the country, those things are not covered. IBC only covers the issues or applications which are civil in nature. Okay. Any question you have, please ask me, so that we can have an interactive session. Okay. Insolvency Law Committee report on moratorium. You know, I mean, subsequently, MCA, Ministry of Corporate Affairs, which is the Administrative Ministry for Insolvency and Bankruptcy Code, they appointed a committee which is called the Insolvency Law Committee to prescribe certain things to improve the provisions of the code. And this Insolvency Law Committee, they submit their report in the year 2020, mention the importance of moratorium period during CIRP to run the corporate data as a. So in the report also, Insolvency Law Committee maintained the importance of moratorium, provision of moratorium in the code, it is stated that it said in the said report that the licenses, permits, and quotas, concessions, registrations, or other rights that the corporate debtor enjoys form the basis of its business, without which it will not be possible to resolve the corporate debtor as a going concern. Friends, kindly mark these lines. The law committee says that licenses permit. These licenses can be FDI license also. The permission can also bring the foreign currency within the country for its business. So law committee said that these particular license, permits, quotas, they are very much essential for the functioning of the company. Maybe the company is now in financial distress. It has come under the purview of the insolvency law. But without these things, the company or the corporate distressed corporate debtor cannot function as a going concern basis. Agree? I mean, the main purpose to run the company. It is not to close down the company. For this reason, the legislative intent behind introducing the provision of moratorium was to bar termination or suspension of such grants by government authorities. So they also support the intention of the legislation that for these particular reasons, the provisions of moratorium is incorporated within the code so that it cannot be stopped by the government authorities. Generally, license permits, they are granted by the government regulatory authorities or the local authorities. But this should not be stopped as per the report of Insolvency Law Committee. As a result, the termination or suspension of such grants during moratorium period would be prevented by Section 14. Section 14 talks about the moratorium. We will see. However, in order to avoid any scope for ambiguity, it has been recommended that the legislative intent may be made explicit by introducing an explanation by way of such an amendment to Section 14(1) regarding termination or suspension of grants on account of non-insolvency risk. So friends, IBC is an economic law. And being an economic law, it always evolves. So there are many jurisprudence which we saw at the latter stage. And they are also, I mean, what should I say? Some unwanted advantage the corporate debtor may solicit because of the provisions of this moratorium. So because of such scenarios, the government was forced to put this, we will see this explanation by way of amendment in Section 41, and it mentioned categorically the scenarios where these licenses, permits, or quotas can be withdrawn for non-insolvency reasons, not related to the corporate insolvency process reason. If there exists some non-insolvency reason, then it can be done otherwise. Okay. These are the sections, I already told you that these are the sections put inside in the code to address the moratorium. The Section 13 is that section where the at the time of admitting the application, the adjudicating authority also ordered for a public announcement by the IRP, interim resolution professional, and impose the moratorium. Section 14 is the main section for this moratorium provision. 31(3), defines the time limit up to which it will be effective. Section 33 for moratorium during liquidation period. Section 74, this indicates the penalties if there is any violation of this moratorium provisions. Then this moratorium is also granted for the person, but this is not our subject matter of discussion. Section 96 and Section 101. You know that now, I think with effect from 2019, the part 3 of some portion of the part 3 talks about the individual insolvency, and this was not notified. This is not notified by the government, but some part of part 3 was notified in the year 2019, and this talks about the personal guarantor, insolvency proceedings for the personal guarantor. And they also enjoyed the moratorium provisions under Section 96 and 101, but we will not discuss this. Provisions of Section 14 of the IBC 2016 are very wide. I said the main provision of moratorium is Section 14 and appear to be a complete bar against the institution or continuation of suits or any legal proceedings against a corporate debtor on the declaration of moratorium by the adjudicating authority. What are the legal contents of this moratorium provision? On insolvency commencement date, the adjudicating authority shall by order declare moratorium for prohibiting all of the following, namely the institution of suits or continuation of pending suits or proceedings against the corporate debtor, including execution of any judgment, decree, or order in any court of law, tribunal, arbitration, planning, or other authority. So, all sort of institution of suits, and not only institution, continuation of pending suits also stop through this moratorium. Transferring, encumbering, alienating, or disposing of by the corporate debtor any of his assets or any legal right or beneficial interest therein. So corporate bar is on the corporate debtor also. Corporate debtor cannot do anything with the assets which it owns by of transferring, encumbering, alienating, or disposing. Any action to foreclose, recover, or enforce any security interest created by the corporate debtor in respect of its property, including any action under the securitization and reconstruction of financial assets and Enforcement of Security Interest Act 2002, that is SARFAESI. So any action to foreclose, recover, or enforce any security interest created by the corporate. Friends, here I want to tell you one thing. This section 14, it deals with the CIRP process, corporate insolvency resolution process. So I told you just before that when the company go into liquidation, suppose that it is no resolution plan is received, or if any resolution plan is received by the committee of creditors, they don't agree to it. They don't approve the plan. There are other situations also. So adjudicating authority will pass the order for liquidation. And this is the second stage. of the corporate debtor. And it is governed by the provisions governed by Section 33 of the code. But when a company goes into liquidation, there is a solution of Section 52. There it says that if any financial creditor who is enjoying the security interest, he may inform the liquidator that he will not relinquish his security interest, which means that that particular financial creditor can take out the asset and dispose it off on its own. But okay, fine. I mean, if he recovers something more, anything more than its original loan amount, that particular, the balance amount should come back, to be sent to the kitty, that liquidation estate of the company. So I will not discuss in details all these things, but generally during CIRP process, foreclosure, recover or enforcement any security interest are stopped, created by the corporate are stopped. Cannot be done. The recovery of any property by an owner or lessor when such property is occupied by or in the possession of the corporate. So the if something is given to the corporate on a lease, it cannot be, I mean, what should I say? It cannot be re-occupied. I mean, the owner, actual owner, the lessor cannot cancel the lease and say that I'll take back the offer. No, it is not possible. The order of moratorium shall have effect from the date of such order till the completion of corporate insolvency resolution process. So we have already seen the definition of moratorium, dictionary meaning of moratorium, that for a certain period of time. So this certain period of time is defined here, that the order of insolvency resolution process, insolvency commencement date, up to the resolution, maybe through resolution plan or by the order of liquidation. Provided that where at any time during the corporate insolvency resolution process period, if the adjudicating authority approves the resolution plan under subsection 1 of section 31 or passes an order for liquidation of the corporate debtor under section 33, the moratorium shall cease to have effect from the date of such approval or liquidation order as the first. So I'm going for any detailed discussion. This, friends, I have just mentioned because, I told you that the interplay of IBC purely depends upon the two particular provisions within it. First is moratorium and second is section 230. That's why I'm giving you some elaborate idea to you on the provision of moratorium. Explanation, which I has already told you, that some amendment made in the provision of section 14 to the jurisprudence, which came through the jurisprudence. It says that it is hereby clarified that notwithstanding anything contained in any other law for the time being in force, a license, permit, registration, quota, concession, clearance, or a similar grant or right given by the central government, state government, local authority, sectoral regulator, or any other authority constituted under any other law for the time being in force shall not be suspended or terminated on the grounds of insolvency, because the company has gone into insolvency, so I'll terminate it. No, it is not possible. Subject to the condition. Friend, this is very important. That's why this explanation came. That there is no default in payment of current dues arising for the use of continuation of the license or a similar grant or right during moratorium period. Many times what was found or what was seen that, because I told you the main purpose to run the company as a going concern. So company, even if it comes under the purview of CIRP, it continues with its businesses. And that's why this license, grant, permission, quota are required for it. But it was seen that though the company is doing its business, selling its product, but they stop paying the royalty or the lease rental, okay, the quota fees, all these things. And when the authority asked, they said we are in the CIRP process. So moratorium is that you cannot do anything. So later on, the explanation was incorporated within the section. It said that if there is any default made for the current use, not for the past dues, for the current dues, if there is any defaultment, then this can be suspended. Because there is then no scope, no point to run the company as a going concern. If they are not able to generate enough money to pay their license fees or quota fees or whatever registration charges, so there is no sense to run these things, continue with these things. So in order to stop such type of misuse, explanation says that if the current dues, not the past dues, are not paid, then this can be suspended. No default in the payment of current dues arising for the use of continuation of the license or similar grant or right during the moratorium period, subject to the condition. Things outside the purview of moratorium, which are not covered by the moratorium, where the interim resolution professional or resolution professional, as the case may be, consider the supply of goods or services critical to protect and preserve the value of the corporate debtor and manage the operations of such corporate debtor as a going concern, then the supply of such goods and services shall not be terminated, suspended, or interrupted during the period of moratorium, except where such corporate debtor has not paid dues arising from such supply during the moratorium period or in such circumstances as may be specified. So similarly for the supply of goods or services, if for the current things it is not paid, then that can be stopped. The provisions of subsection 1 shall not apply to such transactions, agreements, or other arrangement as may be notified by the central government in consultation with any financial sector regulator. When financial sector regulator generally, not generally, it is RBI, Reserve Bank of India, which governs all these acts or statutes related to the financial act, like FEMA, FDI policies, all these things are under the control of Reserve Bank of India. So Government of India, in consultation with the financial sector regulator, may bring some should I say notification or clarification that this is moratorium will not be applicable in that. Otherwise, the provision of moratorium bars that taking out the assets or impose seizure on the corporate debtor under any provisions of the law, including inter alia FEMA. If you have any question, please ask. Honorable Supreme Court of India in Swiss Ribbon Private Limited and another versus Union of India and others held that the declaration of moratorium is in the interest of the corporate debtor by preserving its assets during the resolution process. So I said that the Apex Court also agreed that this should be given This provision should be there in the code. The period within which the said process is to take place again to protect the corporate debtor's assets from further dilution and also protects all its creditors and workers by seeing that the resolution process goes through as far as possible so that another management can, through its entrepreneurial skill, revive the corporate debtor to achieve all the aims, which we have already discussed at the time of discussing the objective of IBC. Okay. So I already informed you that IBC is an economic law. And after the introduction of IBC, many things evolved. Many jurisprudence come, which forms an integral part of the provisions. Maybe if you see the main code, it is not incorporated there. Because you know, as all of you know, that in the next parliament session, the government of India has brought the bill. It is in public domain for making certain changes, amendment in the code. But even then, certain things are now equally applicable in the IBC processes through jurisprudence or the various case laws. And also certain circulars are moratorium is issued by the MCA, Government of Ministry of Corporate Affairs. I already told you that we are discussing about the interplay of IBC on FEMA. You know what's happened, and we also discussed at length the provision of moratorium as per the IBC. But friend, you know what's happened? As a result of which, after the insolvency process of J2RS and Go Air, you know what's happened? Generally, the Indian Airways, they don't own any aircraft of them. They generally take these aircraft on a lease basis from the foreign entities or foreign organizations. Now what's happened now, because of this particular provision of section 14, that is moratorium, if the company becomes a distressed one, the foreign investors, who have given the lease to them, the aircraft, they cannot take back their assets. Because the corporate debtor takes the plea that now the moratorium has been imposed and you cannot take it back. And as a result of which, you know what's happened, that these foreign companies, they are seriously discussing whether they will allow such lease in future to the Indian airway companies. So Government of India, they brought the moratorium circular on moratorium. The central government, wide notification number SO 4321E dated October 3, 2023, notified that the provisions of subsection 1 of section 14, that is moratorium, which are stopped by the provision of moratorium, shall not apply to transactions, arrangements, or agreements under the convention and the protocol relating to aircraft, aircraft engines, airframes, and helicopters. So all these things which are generally are taken on lease from a foreign entity, aircraft, aircraft engines, helicopters, all these things, all these arrangements are taken outside the purview of section 41. That is taken outside the purview of the moratorium. Okay. So these are all about the provisions of moratorium. The provisions of moratorium is really very, very important to understand, to analyze the interplay of IBC with any other statutes, including FEMA. It is our discussion. This is our subject for discussion. So I pause for a minute or for some time. If you have any question, you may ask. Okay.
Excuse me, sir.
Yeah, sure. Tell me.
Sir, actually, the IBC is the overriding provisions of the any other act, according to section
Yeah.
38. But what is some financial institutions, instead of going for the IBC, they are going under the SARFAESI Act.
Mm.
So,
Why?
in such a cases, how to stop it from the SARFAESI Act? Whether we can file suit against the bank financial institutions for the for to override the because of the override provision, we can stop through the IBC.
Actually, you are right. Very right. I mean, it is seen for some past years that financial institutions, especially the banks, they
No,
are
no, they actually what happened there is because of the in a financial institution they will not recover the full amount. Because in IBC there are so many haircuts and everything is there, so they want to stop it and they will get it the full recovery from there by through the SARFAESI by auctioning their secured properties. So that they most of the concerns most of the financial institutions nowadays they are going for this under SARFAESI instead of the IBC.
yes, I agree with you. That is also one of the reasons. But the main reason now, I mean, is the time now taken by the IBC. Because there are many, you cannot blame the court for it. There are many reasons because what should I say? The infrastructure, lack of infrastructure in the adjudication. So there are many reasons, but I can tell you, Mr. Shekhar, that in the recent report of IBBI, I think it is published in the year 2024. Now the scenario little bit changed because you know what's happened. What you are saying, it is possible if the financial creditors, secured financial creditors, I agree with you. They can go for, realize their asset through the SARFAESI Act. But what's about for the unsecured financial creditors? What's about the operational creditors? For them, IBC is the only one. And I'm telling you, apart from that particular, I should not say lacking now, because you know we have seen that in earlier cases, earlier stages, at in the regime of Sika, then all these things, then it takes 4 to 5 years to settle the case. And here the maximum, I think, time frame taken is less than 3 years. Not 4 years. I think it is 7, 8 years earlier, and now it is less than 3 years. But I agree with you that the bank, mainly the Indian bank, they found it something, what should I say? They found it that it is not as per their interest. They want to have the quick recovery, and that's why they shifted towards the SARFAESI Act. But the scenario has changed. Now, I think the IBC has also now becomes a leading provisions of law for the resolution. Another thing, sir, you have to consider that IBC again and again, I reiterated, IBC is not for recovery. IBC is for resolution. And I think there is now guidelines issued by RBI to all the scheduled banks that they should try for the resolution through IBC.
So, correct. What you are saying that it's a correct actually. Because of the resolution, the operation creditor also the claiming it. So they are not able to recover the financial institution. They don't want to lose their money. So they to avoid the haircut and to avoid the proportionate amount of their loans and everything. So they are opting for the SARFAESI Act. See, in such a cases, the operational creditor, what will do for that? Whether we can file against the financial institution in the NCLT, or possibility any other possibilities are there.
Now, even if that financial institutions file litigation under SARFAESI Act, I think others can. It is open to others for file the application under IBC also, isn't it?
That's right.
But
If
then
it is,
nobody will stop them. That
if it
your
is
voice is
filed,
getting
filed under, if it is filed under the IBC in the
uh,
NCLT, then automatically the SARFAESI will come to standstill. No.
Of course, yes, of course, yes. That's why I'm saying that in the recent report published by IBBI, I think the scenario has changed again. IBC
So,
has again, regained its supremacy over surface, because now the
yeah.
bankers also now, they realize that, they again come back to the application under IBC law.
No, sir. Actually, what happened there, because the financial institution, what they are thinking that due to heavy haircut, and another thing is expected level in IBC also. What is the timeline is not maintained, even though there is a maximum 330 days. That as far as nowadays there are more than 300 days. Some cases are going beyond the 330 days. So many cases are taking place because of the so many multiple litigation involved. So normally though in IUC it is a fixed as a timeline, that nothing is completed within the timeline. As far as my concerned, whether I am
Right,
correct or
sir, but
not,
you're right, sir. You're right. I'm not disputing you. But have you seen the recent amendment bill issued by the MCA? Categorically, they have addressed these things. I
okay,
agree with you. But they have
okay,
categorically addressed this timeline. They
yeah, they have
said that they again they have reintroduced that the admission of application should be done within a specified period of time. Earlier, when I handled the case, I think my first case was in the year 2017. And I have got the admission order within 14 days from Kolkata NCLT.
that IBC.
Initially said this was happening. This was happening initially. But okay, I cannot comment on this, but now I fully agree to. But again, if you see this amendment bill, they again are going to reimpose this timeline, at least the admission of application.
Okay, okay, okay.
So maybe there are certain point, uh, but IBC, IBC. One thing, Mr. Shekhar, I can tell you that if you want to compare IBC with Surface, it is not an apple to apple comparison, according to me.
Hmm.
Comparing SARFAESI with IBC is absolutely not an apple to apple, because IBC also addresses certain things which is not available. I agree with you that maybe the recovery will be fast. They are getting, their money back. But if you see the economy as a whole, definitely IBC has the supremacy.
Okay, sir. Okay, okay. Thank you.
Thank you. So another important provisions incorporated in the code is section 238. I have already told you that through this obstante clause of under section 238 has given IBC an overriding power on any other act or laws for the time being enforced in the country. It reads that the provisions of this code to override other laws which states that the provisions of this code shall have effect notwithstanding anything inconsistent. If anything is inconsistently mentioned in IBC, then also it will be, it will get the supremacy. Contained in any other law for the timing in force or any instruments having effect by virtue of such law. It is also referred to as non-obstantity clause. By this section, one can assert that this section has an overriding effect over the provisions of other acts. The drafters of IBC code wanted the IBC should prevail over other law. And I think there in my subsequent slide, this is also accepted, or what should I say, the same opinion was expressed by our apex court, Supreme Court. It says that being an insolvency law, it must have the overriding power over other. The provision of section 238 can be interpreted as follows: notwithstanding anything inconsistent, means that if any other law or legal documents like a contract, regulation, or rule contradicts the IBC rules will take precedence. So the wordings in this provision categorically put the word notwithstanding anything inconsistent. Any other law for the timing in force refers to all existing laws in India, such as Companies Act, Income Tax Act, Electricity Act, our FEMA, Foreign Exchange Management Act, everything. Any other law for the timing in force. Any instrument having effect by virtue of any such law includes things like contracts, agreements, or government notifications that are legally binding because of other. So even if there is any government notification, binding government notification issued under the provision of other laws, for those also IBC will get the supremacy by virtue of section 230. Section 238 ensures the supremacy of IBC when it comes to insolvency matters. But only one thing, that this supremacy definitely is, no? Because IBC deals with the supremacy matters. Insolvency matters. So this supremacy only be available when the insolvency matters comes into picture. If another law or legal document tries to interfere with the IBC process, the IBC rules you will. One of the main reasons behind IBC's success can be attributed to section 238, which ensures a hassle-free process for resolution and liquidation. Again and again, I'm telling you, sir, that the main idea under IBC is to have the resolution, not the recovery. The apex code in its judgment affirms the supremacy of IBC over other laws by virtue of this section 238. Accordingly, any legislation's provisions shall cease to have any effect in case of inconsistency with IBC. It is important to note that the jurisprudence decides that when both statutes contain non-obstantity clause, IBC has the overriding power. FEMA also, not FEMA, PLMA has non-obstantity clause. Similarly, if any other act, they have this notwithstanding anything contained in other statutes also have this type of things, provisions. But it is now a settled position that IBC will have the overriding power. There have been numerous pronouncements by different courts hailing the dominance of section 230. India is increasingly connected to global financial markets. Section 238 ensures foreign laws or agreements do not interfere with the domestic IBC proceedings, aligning with international standards like the ancestral model law, a global framework for research. So, IBC also aligned with this ancestral model law, and through this section, it ensures that foreign laws and agreements do not interfere with the domestic IBC proceedings. The jurisprudence observed that when both the laws are special in nature, the latest law shall trump over the older law. It is now a settled stance that in case of discrepancy, the latest enacted statute shall outperform the functioning of older statute. Further, the upper hand, sorry. Further, the upper hand of IBC over other law can be easily made out in the way that it aligns with the objective of IBC, that is to maximize. I told you now when we discuss about the objective, the main objective of the IBC, one of the main objectives of IBC is the maximize the value of assets and to consider the interest of all the stakeholders. That's why the IBC, because of these things, IBC has been given the upper hand over other laws within the country. However, there lies a caveat that the given provision is not absolute and it shall have no effect where the very object of the parties to escape from the liability under other state. So of course, yes, though there are the overriding power under section 238 or the stoppage of activities under moratorium, I have already mentioned that these provisions are not applicable to the are applicable only for the corporate debtors. Anything related to a personal director, an individual director, or an individual management personnel, the provisions or the applicability of section 14 or section 238 will not be applicable. So if it is seen that it is to escape, the party wants to escape its actual liability, its genuine liability under the clear of the provisions of IBC, it is not available. There are many, many cases. That's why the IBC is a very interesting subject, I'm telling you. Report of the Parliament Joint Committee. You know what? When IBC was introduced in the Parliament for the approval, then it go to the Rajya Sabha and then President's consent. So Parliament, I mean the Lok Sabha, they formed a joint joint committee to go through the code. I think it is in the year 2015. Yeah, 2015. It was introduced in Parliament in 2015. So the Joint Committee of Parliament on Insolvency and Bankruptcy Code in its report dealt with the conflict of IBC with other laws. So they also admitted that time, and when this particular code was reviewed by the Joint Committee, they also apprehend that there may come some conflict between this particular code and other law within the country. The committee stated that from a constitutional perspective, a parliamentary law on insolvency and bankruptcy can override other laws on this subject matter. That's why I told you that It is already accepted that if parliamentary constitutional perspective, a parliamentary law on insolvency and bankruptcy can override. It should have the power to override other. However, there are 2 points of specific concern. First, certain categories of secured creditors and tax authorities have special power granted to them under extant laws. Second, the number of adjudicating authorities under the various laws is large and appears to be growing. So these 2 issues may affect if that time, because it was not enacted, no, and this was not notified, that code. So the Parliament Committee, Joint Parliament Committee said that this supremacy is okay, but this may be affected by certain categories of credit and tax authorities' special powers. I think recently, I think you are aware of that, the Supreme Court order on rainbow paper, isn't it? Because GST people, Supreme Court said also, they are also secured creditors by the operation of law. And second, the number of adjudicating under various laws are large and appears to be growing. The adjudicating authority under the code needs to have the requisite jurisdiction to deal with the conflicts that may arise due to this. So NCLT, I mean, I don't think that it was discussed. I mean, decided that NCLT will be the adjudicating authority for IBC. I'm not sure, but I think it was not decided by them. So, but they felt that the adjudicating authorities must have the sufficient power, requisite jurisdiction to deal with the conflict that may arise due to the overriding power granted to the court. However, it was observed subsequently by various case laws that there will exist no inconsistency between the acts where the object, purpose, text, and the context of both these resolutions are different from each other. It is suggested that attempt should always be made to interpret and interpret statutes harmoniously so that they can peacefully coexist. So, after the introduction, when in the many conflict cases, the court has ordered that, okay, in this particular case, IBC cannot override the provisions of the other law or other act because there is no, because they both the acts or laws are now in this particular case. Again, it is on case-to-case basis in a different plane. So since in this particular case, they are operating in the different plane, so there cannot exist any inconsistency. Because if you see the language of section 230, it said that notwithstanding anything which is inconsistent with provision of IBC. So in these cases, the court has directed or has given order that there cannot be any inconsistency because for this particular case, they are operating in the different aspects. So it is very much important to harmoniously interpret the provisions of IBC and that particular law or act to see whether the IBC will override these things or not. And the main purpose that both the laws, because those laws or acts, FEMA is also introduced for a particular or with a particular objective or for a particular reason. So there is FEMA should also coexist peacefully along with IBC. If every time the IBC overrides FEMA for each and every matters, then the purpose of introducing FEMA may be defeated, isn't it? So these are all about the Section 238, the provision incorporated in the code, providing the code overriding power. Okay. Again, I pause for it for some time. If you have any question, you can.
Sir,
Tell me. Yeah.
sir, you are saying that the 238 is override the provisions of the FEMA.
Just a minute. Ek minute. I can
Uh,
see.
can you quote an example? Can you quote an example that in which case the FEMA, the 238 override the provisions of the FEMA? Any other examples are there?
Yes. I'll come to you. I'll come to you. Definitely come to you. There is a case law. I'll definitely explain.
Okay.
Just keep it in your mind. Definitely it is there. Okay.
Okay, sir. Okay, thank you.
Thank you. There is a case law. So we have already seen the object. We have already discussed the objective of IBC. Now we will see the objective of FEMA, because I just now I said that FEMA also brought into the place with some definite defined objective. So what are the objectives of FEMA? The objective of Foreign Exchange Management Act or 1919 of FEMA are to facilitate external trade and payments, promote the orderly development and maintenance of foreign exchange market, and provide a regulatory framework for managing foreign exchange transactions. And again, I am telling you, in order to develop the country's economy, bringing the investments from abroad is very, very essential. Had it been a developing country, or even if it is a developed country, it is absolutely not possible for a country to generate each and every requirement of its own requirement in-house through the operations within the country. Absolutely not possible. So the foreign transactions or overseas transactions are very, very much important for the purpose of economic growth of a country. And this FEMA, the main objective of FEMA, for which it was brought into, is to address the facilitated external trade and payments, promote orderly development and maintain foreign exchange market, etc. Okay. FEMA simplifies the procedures for international trade, attracts foreign investment by ensuring stability, and allows the Reserve Bank of India to regulate foreign exchange dealings while shifting the focuses from criminal offenses to civil ones for violation. I'll come to this, but even then, I can tell you that FEMA has replaced another act which was called FERA. And FERA was a draconian act or statute. Provisions of the FERA contains the criminal provisions, and many people has put under the bar because of violation of FERA. That's why to make the country nobody wants, whether the violation is intentional or non-intentional, but nobody wants to go behind the bar, isn't it? So in order to make the country a business-friendly economy, bring the business-friendly economy, this FEMA was introduced to replace FERA. That's why by this FEMA, the shifting of the focus made from the criminal offenses to civil offenses for violation. Now it is penalties and fines. No, I think very, very hardly any activities which has the imprisonment provision. Maybe one, I can remember. So the key objective of FEMA is promote external trade and payments, by simplifying the rules for foreign exchange transactions. FEMA makes it easier for Indian businesses and individuals to engage in international trade, which boosts the economy. So one of the main objectives is to promote external trade, to promote the international transactions, encourage foreign investments. The more liberal and transparent framework under FEMA makes India a more attractive destination for foreign investors. That's now we discuss. Clearer guidelines encourage more capital inflow, benefiting Indian economy. Establish a managed forex market. Unlike earlier situation, which focus on strict control, FEMA focuses on managing foreign exchange. There is a default earlier, and now it is the manage, how you will manage the foreign exchange. This promotes an orderly, well-managed and stable foreign exchange market in India. Okay. Consolidated and amend foreign exchange laws. FEMA provides a clear legal framework for all foreign. Friends, I am discussing with you these things in detail, because each and everything is affected or has the effect while a company goes into insolvency phase. Because I told you that the company is now that time during the insolvency, the company will also operate as a going concern. So each and everything will also be applicable for the company which is in financial distress. And this provisions is also equally applicable. FEMA provides a clear legal framework for all the foreign exchange transactions, which are classified into two categories. Current account transactions. I think all of us know about it. For routine day-to-day international transactions, such as payment for trade, education, and travel. So a distressed company is also required to undertake the current account transactions through foreign currency. Maybe. Capital account transactions. For transactions that alter the assets or the liabilities of a resident outside India, such as foreign investment, which are more strictly regulated. I told you that during the resolution plan, the resolution applicant may opt for the foreign direct investment or ECB. So all these are capital account transactions, and these things are governed by the FEMA. Boost economic growth. By facilitating global trade and encouraging foreign investment, FEMA helps to stabilize the value of Indian currency and supports overall economic growth. Ensure compliance and transparency. FEMA created specific procedures and guidelines for foreign exchange dealing and made violations a civil offense rather than a criminal offense. Criminal law. This shifted the focus from punishment to promoting easier compliance for business and individuals. FEMA replaced more restrictive, just now I told you that more restrictive Foreign Exchange Regulation Act, FERA, and changed the nature of violation from criminal offenses to civil offenses, allowing the penalties and fine instead of imprisonment. It liberalizes the Indian economy and make it more globally integrated. So if the foreign investors, they found that the provisions are of the country act is not so draconian, they will be free to move in the country now with their money. If they find that they can take out their money, they have the means to exit, they will come. They will do business in the country. And this has happened for India, in India. Various types of transaction routes affecting by FEMA. So FEMA, there are various routes through which the foreign currency may come within the country. One is foreign direct investment, FDI. Is the investment through capital instruments by a person resident outside India. Look, this FEMA, it is understood that the FEMA always deals with the international transactions with foreign currency. Had it been the Indian, okay, there are some exceptions or some, what should I say, some peculiar circumstances where the provisions of FEMA is applicable even when the transaction is done through the Indian currencies. But okay, that is different. We are not going for all these details. But generally, it handles the international transactions through foreign currencies. So one is FDI, capital instrument by a person resident outside India in an unlisted Indian company of 10% or more of the post-issue paid up equity capital on a fully diluted basis of a listed Indian company. So foreign direct investment is one of the routes to which the foreign investment can come in India. Second is external commercial bond, or ECB. Refers to the loans in form of bank loans, buyer's credit, supplier's credit, securitized instruments available from non-resident lenders with minimum average maturity of 3 years. So if this has the minimum average maturity of 3 years, then the loan from foreign banks, buyer's credit or supplier's credit are classified as a route for bringing the foreign exchange within the country. And that route is called ECB, for external foreign commercial bonds. Both FDI and ECB can be executed through either automatic route. Automatic route means no prior approval of government or RBI is required. Or government route, prior approval from the government is needed, though through the Foreign Investment Promotion Board, FIPB. So, but nowadays, most of the transactions are put under the automatic. Very few things, I think defense things and some others. Defense, I know. Maybe some scientific activities within the country. They are put under the government approval through FIP. Otherwise, everything is under automatic. So FDI or SEB can be either through automatic or through government approval. There is overseas direct investment. This is now the Indian company investing to others in the outside country. Means direct investment outside India by way of contribution to the capital, subscription to the memorandum of association of a foreign entity, or by way of purchase of existing shares, either by market purchase or private placement, or through the stock exchanges, signifies a long-term interest in such foreign entity, like joint venture. So when a Indian company forms a joint venture, definitely it contributes to the share capital, isn't it? And if the joint venture is situated outside India, then it will be termed as the overseas direct investment and will be governed under the provisions of FEMA, but does not include portfolio investment. Like FDI, ODI also involves automatic route and approval route. So some activities are there for which you can, without any approval, you can invest outside the country. But there are also certain activities for which you have to have the prior approval. While the meaning is the same, industries covered under automatic route and approval route are different than the case of it. So the list, the inclusion of the business activities are different from FDI to ODI. Debt versus equity overriding effect of IBC. Mr. Shekhar, you asked now, where is the overriding things has come? This case also deals some, there is another case I'll tell you, but this case also deals with the overriding provision of IBC on FEMA. The serious things question was raised whether a particular investment falls under the purview of IBC or not. That is, whether such investment is considered to be a debt or equity. Section 5.8. If you see the definition given, financial debt given under section 5.8 of the code, it categorically says that financial debt will not include equity. Equity will not come under the definition of debt. So what's happened in this particular case? SGM Webtech Private Limited versus Boulevard Projects Private Limited. The principal bench of NCLT New Delhi has clarified whether foreign investment via FDI route are to be treated as debt or equity. So if some foreign investment comes through FDI, whether that will be termed as a debt or equity, this was decided under this particular case by principal bench of NCLT. The NCLT, by order dated 31st January 2020, has held the view that fully and compulsorily convertible debentures, FCCD, are to be construed as debt if at the time of application of corporate insolvency, such instrument is yet to reach maturity date. So, though it is a compulsorily convertible debentures, it will be converted into equity. The NCLT has directed that even in case also it will be considered as debt, financial debt under section 5.8 of IBC, provided this is not matured, that conversion period has not come at the time of application of corporate insolvency. So it has to be reached maturity date. Initially, the resolution professional rejected financial creditors' claim on the ground that as per the provisions of FEMA 1999 and allied regulations, the aforementioned instrument in question falls under the ambit of equity and not debt. So if you see the provisions of FEMA, this compulsorily convertible debentures are considered as a part of equity and not as a debt. So on the basis of the provisions in FEMA, RP rejected the claim of the creditors or the person because he said that it is not a debt, financial debt for the corporate debt. And thereby not providing the status of a financial creditor. The decision of RP challenged and the appeal was filed before the NCLT principal. The adjudicating authority questioned the decision of RP on several grounds. Inter alia unconverted debentures to be considered as a debt instrument. There is no ambiguity as to inclusion of debentures as financial debt under Section 5A. So though it is at the version of Section 5A, but you can see that IBC can have an overriding effect, or interplay of IBC can change the status of the investment. Because this thing is considered as equity under FEMA, but as per the court jurisprudence, that it should be, since it is not matured, it should be considered as a financial debt. However, the order classified FCCD as the debt and not equity. The decision was based on the facts and evidence of the case. Definitely, it is a case-to-case basis. That's why I say that it is evolving. Code is evolving each and every time. The balance sheet of the CD highlighted the borrowings as debt, and TDS was paid on the accrued interest, and the instrument was not matured on the date of filing of insolvency petition. In absence of such circumstances, the decision of such instrument, being debt or equity, might get complicated. So in this case, this has happened because of this situation, that balance sheet classified as the debt and TDS also deducted on the interest rate. So the principal bench is of the opinion that this will be considered as debt, financial debt, though as per the provisions of FEMA, it is considered as an equity. However, it may be noted that adjudicating authority in this case directed the supremacy of IBC over the FDI norms under FEMA, since FCCDs are classified as equity instrument as per FDI regulations. So definitely the supremacy of IBC is established through this case law or through this jurisprudence. The Honorable Apex Court also upheld in many cases that the court shall have an overriding effect on SEBI rules, income tax rule, T Act, and other regulations, including FEMA 1990. The rationale behind the same is certainly to ensure the smooth functioning of IBC without any hindrances that may be caused due to inconsistency between two laws. So, for the smooth functioning of IBC without having without creating any hindrances because of the inconsistency law, IBC, even Supreme Court has given the supremacy to the provisions of IBC. It must therefore be borne in mind that such an overriding effect only pertains to situations when there is any inconsistency between two applicable laws. At this juncture, it is also pertinent to observe the legal maxim, leges posteriors pares contraries abrogant. Leges posteriors pares contraries abrogant, which implies, it is very important, when the non-obstante clause forms part of both of the special laws, some special laws comes and both the special laws have the non-obstante clause. Such law which was enacted later chronologically shall override the former. So if non-obstante clause presents in two special laws, FEMA is also a special law, IBC is also a special law. FEMA for controlling the foreign exchange transactions, management of the country, IBC for the resolution. There are some non-obstante clause in FEMA also. But because of the leges posteriors pares contraries abrogant, the non-obstante clause of IBC will prevail over FEMA. Here shall override the format. Intricacies of foreign investment and its interplay with IBC. Sir, if you have any question, please ask me. Foreign investment can be in various forms, such as foreign direct investment. We have already seen foreign portfolio investment, external commercial borrowings, etc. While the key intricacies of such foreign investment incline towards investment activities, it has the interplay with IBC as follows. So, under this following situation, the foreign investment has the interplay with the provisions of IBC. Firstly, the stressed assets. The key aspect of resolution process under the IBC is to secure a revival of the corporate debt. A resolution plan is laid out by the resolution applicants and approved by the committee of creditors as it suits their interest. So this we have already discussed, that for the resolution purpose, IRP or RP, invites for the resolution plan. The person who submits the plan is called resolution applicant, and after getting the plan, it may be approved by COC if it suits their interest. In 2019, the RBI has afforded a new avenue for resolution applicants and the COC. The RBI has rationalized ECB norms and permitted borrowings via approval route from approved foreign entities / lenders for repayment domestically availed rupee loans on the precondition that if such borrowing is permitted by the resolution plan, an eligible corporate borrower can avail loan to repay and divide itself. So RBI what said that in 2019 that for the purpose of this resolution plan, resolution plan generally indicates how the debts will be satisfied, of the corporate debt, the financial trust of the corporate debtor will be satisfied. That is how the, in other words, how the creditors of the corporate debts will be paid. So if for this purpose, if it is required, the resolution applicant is permitted through an automatic route to bring ECBs for the repayment of domestically available rupee loans for the production for the on the period that if such borrowing is permitted by the resolution plan, an eligible corporate borrower can avail loan to repay and revive itself. So for the rupee, maybe the borrowing and the loan are in the terms of rupee, but even then the resolution applicant can bring the foreign investment or foreign money from abroad through automatic route to satisfy those Indian rupee loans. Okay. Therefore, such debt instruments can not only be used to raise capital and finances by eligible Indian companies, but can also aid the process of bidding on trade assets. Bidding on preparing or on submission of the resolution plan. The liberal approach of RBI is structuring regulations for ECB provides a wide window for investment via ECB. Investor as financial creditor. ECBs are loans sanctioned by approved lenders to eligible resident borrower entities. Such loans can be in the form of debentures, bonds, floating, so fixed rate notes, etc. And FCI, foreign currency instruments or INR dominant. So these bonds can be either in the foreign currency instrument, in the foreign currency, or it can be in the INR. Section 5.8 of the code categorically recognizes loans and the aforementioned credit availing instrument as financial debt. Everything which is mentioned there, debentures, bond, putting fees, bond, all are comes under the purview of Section 5.8, which defines the financial debt of the corporate debt. Such classification secures the foreign entity the right to file insolvency petition under Section 7 as a financial creditor against the defaulting borrower. The time-bound resolution mechanism enables the disbursement of dues in a prompt manner, thereby ensuring a secured position to the creditors. It is pertinent to mention that master directions also permit the conversion of ECBs into equity under some provisions. It can be converted into the equity of the acquired business of the corporate debtor. But certain provisions are mentioned. Thus, it is necessary to throw light on the fact that adjudicating authority have categorically held that equity cannot form part of the financial debt. Therefore, any foreign investment in the form of equity cannot be construed as financial debt, owing to the introductory words in the definition of financial debt. So, because of the thing, now we have already seen that NGM case that it said that no, that they said it is a financial debt, but there are the cases where they said that if it is converted into equity, then it will not be part of the financial debt. So here also the though it is a commercial borrowing, but as per the provisions or as per the jurisprudence of IBC, this conversion of ECB into equity will not be termed as the financial debt. So these are the intricacies of foreign investment. As for ECBs, it was certainly considered a welcome step in twofold benefits. Firstly, cheaper and cost-effective route to raise overseas funds to discharge dues of CD, which would in turn help in the realization of the objective of the code and maintaining the efficacy of the code. Secondly, providing viable options to foreign investors, thereby resulting in increased inflow and window for foreign investment in the country. The simplification of the framework governing ECBs has been a successful venture, as the figures indicate a surge over the years. However, there are almost no data to reflect upon the access to reflect upon and assess the success of ECB in IBC region. Though there is a surge of ECBs, but for how much is for the IBC per region, there is no data available. The liberalized norms were much anticipated to facilitate the restructuring of distressed companies. However, since its announcement, provisions for pressed assets restructuring find no mention in RBI or IBBI reports. So the reports of IBBI or RBI, it doesn't indicate that how much ECB has come within the country for IBC purpose. The non-availability of data raises questions as to why has this route has not been able to turn its initial acclamation into a reality, whereas there can be no one definite answer to it. There can be no one definite answer to it. The fundraising via approval of route has never been easy, which can be anticipated as one of the reasons for unexplored scheme. Furthermore, since mandatory compliance of ECB framework norms, such as pricing norms, exchange rates, etc., is to be observed, as per the master directions, the prevalent market forces and conditions would also impact its performance. While certain ambiguities remain, the concerned authorities should have ensured the desired implementation of this restructuring scheme. So these are the intricacies of foreign investment and interplay with IBC generally for getting the ECBs or foreign investment for the acquiring the stressed assets, then investor as a financial creditors. So if you have any question, please ask me. Otherwise, we will go to this landmark case law and where I will show you that how the provision of IBC of section 238 overrides the FEMA provisions. Okay. So I just pause for a minute, or can we have a break for 5 minutes? Hello? Can we have breaks for 5 minutes? Moderator, anyone from ICSI? Hello? Anyone from ICSI? Hello?
Sir, no one from ICICI, but we can have a break of 5 minutes.
Just 5 minutes. Yes, 5 minutes break, then we come back. Okay.
Yes, sir.
Yes, sir, definitely we can.
Yeah, thank you so much. I just keep my slides open. Just 5 minutes, that will come. So can we start now? Hello? Hello? Can we start?
Yes, yes.
Okay. Just a second. So now I'll discuss with you on landmark judgment of Calcutta High Court, because this is out of a writ petition filed. And this shows this judgment. I think Mr. Shekhar asked for that. Where is there any case law for overriding the provisions of overriding effect of the provisions of.
Any appeal on this matter, sir? By
I'm not
RBI?
aware, but I don't think so, because it is, I think, sometime in July 2025. So I don't
Case
think
law. This judgment came in which year, sir?
this is in 2025,
Okay.
July, I think, July 2025.
Okay.
I am not aware any appeal.
No.
Appeal means this is writ petition, no, I think, and it is in the single. I don't think that anyone moved to the division bench, because it's a single bench order. I don't think anyone moved to the. Okay, the Anup Kumar Singh versus Union of India versus others. The Calcutta High Court judgment in Anup Kumar Singh versus Union of India and others reaffirms the primacy of IBC over FEMA in corporate insolvency proceedings by reinstating the moratorium under IBC bars enforcement actions under FEMA. This case arose out of the liquidation of Sri Ganesh Jewellery House India Private Limited, where the court quashed the Enforcement Directorate seizure order issued under FEMA on the ground that they violated the court's moratorium provisions. Crucially, the court relied upon the non-obstante clause enshrined under Section 238 of the IBC and binding precedents to conclude that once the insolvency proceedings under Part 2 of the code are underway, all inconsistent provisions of FEMA must be. Okay, so both these overriding things came under the order of Calcutta High Court, both from the point of view of moratorium and also the non-obstant clause of non-obstant provision of Section 238. This decision underscored the IBC's comprehensive scheme to centralize corporate debt resolution and protect the corporate debtor's estate from external attachment. Part 2 of IBC establishes a two-stage corporate insolvency process, that is corporate insolvency resolution followed by liquidation. We have already discussed on, with a compulsory moratorium on creditors' remedies to preserve the corporate debtor's asset. Section 14(1) of the code declares that on the insolvency commencement date, the adjudicating authority must declare a moratorium by order during which no suit or other legal proceeding shall be instituted or continued against the corporate debtor. These are all the observations of the court, Calcutta High Court, recorded in the order itself. Likewise, after a liquidation order is passed under Section 33(5), provides that subject to Section 52, no suit or other legal proceedings shall be instituted by or against the corporate debtor unless brought by the liquidator with the court approval. So even if the corporate debtor cannot file any suit or legal proceedings, cannot undertake any legal proceedings unless and until the liquidator takes the approval from the adjudicating authority. And this section 52 we have already discussed. This is the relinquishment of security interest. So only section 50 subject to the section 52, nothing, no change in the assets position of the corporate debtor in liquidation will be allowed. The effect of this provision is to bar both new and pending proceedings against the corporate debtor from the start of insolvency until its conclusions. As the court emphasized, this moratorium ensures that once the corporate debtor enters the IBC process, its assets would not be attached, but instead would be disposed of through the CIRP or liquidation. So again, that question comes whether an individual or a government authority can attach or can take over the assets of the thing. Court said no, it cannot be done. It can only be sold or disposed of either through the process of CIRP or in the liquidation process. You all know that liquidation process, the liquidation estate is formed by the liquidator and then it's sell the assets and pay off the creditors. Okay. Indeed, by design, the courts seek to aggregate the corporate debtors' assets into insolvency estate for an orderly sale or resolution plan, maximizing the value available to creditors and other stakeholders. The IBC overriding clause is expressly engraved under section 238, which provides that the provisions of this code shall have effect notwithstanding anything inconsistent therewith contained in any other law for the time being in force. Thus, a later enacted statute, herein IBC, supersedes any earlier statute to the extent of inconsistency. So this is drawn, this decision or this direction was drawn from the provision of section 238 of the code. In Anup Kumar Singh, the court relied on section 238 to hold that FEMA cannot override the court's moratorium. The judgment quotes numerous Supreme Court rulings upholding this principle. I have just taken the gist. So I suggest if you are really interested, you can go through this judgment. Several Supreme Court judgments also recorded in the judgment itself.
Which judgment, sir?
This Anup Kumar Singh versus Union of India.
Same judgment. Okay.
Yeah. So you go through the judgment. This is the, I have take the extract from the judgment, isn't it? Cannot override the court, the judgment courts and numerous Supreme Court rulings upholding this principle. The Calcutta High Court noted a catena of decisions has consistently applied section 238 to displace conflicting enactments. The authorities show that the legislature intended the IBC to subsume other laws in insolvency, to which FEMA is no exception. So any matter related to insolvency, IBC subsumes anything, each and every law for the time being in force within the country. And court said that FEMA cannot be an exception for this. In short, court's moratorium is given statutory primacy, and any enforcement step inconsistent with it must end. FEMA Section 37A empowers ED to provisionally seize the properties of any person who contravenes certain foreign exchange regulations. Once such provisional seizure order is issued, ED may confirm it and thereby attach the assets. So this is the provision in FEMA 37. Normally, these powers are exercised to protect India's foreign exchange regime. However, when the target of such enforcement is also undergoing, however, when the target of such enforcement is also undergoing IBC proceedings, a conflict may arise. So, if this seizure authority is granted to ED under Section 37A related to a company undergoing CIRP, definitely there will be a contradiction, or there should be a conflict between the IBC provisions of IBC and FEMA, isn't it? On one hand, FEMA enforcement is a statutory power to attach property for default of foreign exchange obligations. On the other hand, IBC moratorium forbids any attachment or legal proceedings affecting the corporate debtors' assets. So these are the conflict. And here I already told you that court generally says that whether there is any inconsistency, if these two statutes operates in a parallel plane, separate plane, then there should not be any inconsistency. But here, you know what's happened. The attachment of property, definitely, it is not in the separate plane. So there comes an inconsistency between two acts, and definitely IBC will get the supremacy. In Anup Kumar Singh, the sequence of events concretely illustrated this tension. The CIRP of Sri Ganesh commenced in February 2018, and by September 2018, the NCLT had ordered the company's liquidation, appointing petitioner. This Anup Kumar Singh is the liquidator of the Sri Ganesh corporation. Nonetheless, the ED issued a provisional seizure order under Section 37A of FEMA in November 2022 and later sought its confirmation in January 2023. These actions came years after the liquidation order and hence during the court-mandated moratorium. The liquidator filed a writ petition arguing that both the seizure and the notice to appear violated the IBC moratorium and thus were void. He relied on Section 238 and precedents to contend that FEMA proceedings could not continue against a corporate debtor in liquidation. The Honorable Calcutta High Court largely agreed with the liquidator's position, and the court began by recalling that Section 14 not only prohibits the initiation of new suits after commencement, but also the continuation of any pending suit or proceedings. Here, the FEMA case was pending since November 16, that is before CIRP, and continued after liquidation. Thus, Section 14 barred its continuation. After liquidation was ordered on 14 September 2018, Section 33(5) further barred any new proceedings against Sri Ganesh, the corporate debtor, without court permission. In other words, under court scheme, the debtor's asset would no longer be touched by third parties. They had to be dealt with through the resolution plan or liquidation sale. Further, such position also tracked Section 32A2 of the code as well, which provides that no action shall be taken against the corporate debtor's property for offences committed prior to CIRP, once the resolution plan is approved or assets are sold. Although Section 32A did not directly bar the ED action here, 32A is for the CIRP and the resolution plan approved after the resolution plan approved and by the COC and the NCAT. So this particular section doesn't have any direct bearing on this, but in this case, the CD scissor. But you know what's happening? The court mentioned this thing that to reinforce that, look, this is also given in this particular section also. That nothing can be, that assets of the corporator cannot be touched up. Although it did not directly bar the ED action here, the logic under section 2 that the asset cannot be seized, cannot be touched once emerged in the court process, reinforce the moratorium purpose. Thus, on plain language, section 14 and 33, no proceeding, whether criminal, whether criminal, regulatory, or civil, affecting the corporate debtor could run its course outside the code once insolvency and liquidation begin. The court next addressed the statutory conflict. The FEMA is an older statute, 1999, lacking a non-obstante clause. It could not override the newer code. In contrast, Section 238 of the IBC explicitly gives the code overriding effect over anything inconsistent in other laws. The court pointed out that when Parliament enacted the IBC in 2016, it consequently left Section 238. We have also read the Joint Parliamentary Report. Consequently left 238 in place to bind all existing laws, including FEMA. So this is the observation made by the court in its order. You look, the intention of legislature is very clear, because since the keeping of this particular section, because they have already discussed that conflict may come because of this overriding power given to IBC through this 238. But even then they kept this section as it is in the code. So Calcutta High Court said that it is the intention of the legislature to have these things in place. Clear? So that it can binding all existing laws. And FEMA is also within that. The Calcutta High Court concluded that continuing the FEMA actions against Sri Ganesh was impermissible. So FEMA actions against Sri Ganesh cannot be permitted. The seizure order of November 2022 and the confirmation notice of January 2023 were each issued in complete disregard of the moratorium under Section 33(5) of IBC. The Section 33(5) talks about the moratorium for the CD under liquidation. By extending Section 14 to pending cases and enforcing Section 33(5), the court held that these actions could not lawfully proceed. In its final paragraph, court stated unequivocally, in view of the proceedings pending under the IBC and the orders passed therein, the impunged provisional seizure order and the impunged notices would not have been issued. Therefore, the impunged notices are quashed. So, Calcutta High Court was the notice and also the order for seizure by the ED under the provisions of FEMA and gave the supremacy of IBC because of its section moratorium, because of the provision of moratorium under it, and which is supported by section 238 incorporated in the code. Yes. Any question? Mr. Shekhar, I think you got your answer.
Hello.
Yeah, tell me. It is clear, sir? You said that overriding effect of 238 upon FEMA. So this order categorically said. Look,
Actually, my clarification is FEMA is dealing with the for a money what is a foreign exchange as well as any investment in India or whether we have to invest in India. See, the IBC is a mostly it was in the liquidation stage, liquidation or whatever it may be there. IBC, what is for recovery of the recovery? What is the resolution? With regard to the resolution. See, only the company is having the tie-up with the foreign companies and other things. That then only the FEMA will exist.
Yeah.
So the overriding clause in actually it applicable at what stage actually, because the whatever it may be there, whatever we are violating or whatever is not permitted in the FEMA, that we have to obtain the permission from the RBI according to my knowledge. Okay.
Right.
Then
Yeah.
where is the where actually you are saying that it is a overriding the FEMA Act. So the FEMA is only dealing with the giving the guidelines for the foreign exchange as well as the for investment or either in India or either outside India. That only is there. See, even for the settlement of the shares also, that is already some NRI is invested, then we have to pay the amount. That is law is already permitted. So that means the overriding clause will not, at anywhere it will, in the FEMA it will not affected. It is my view actually. That only I want to explain for that.
Sir, I think you can recall my discussion earlier that I categorically said that unless and until, if these two, not only, FEMA, any acts or laws operates in different plane with IBC, there will be no inconsistency.
Yeah, that I agree.
Inconsistency only comes when the matters has referred to the insolvency process.
Yeah.
In this particular case, the Sri Ganesh was referred to liquidation. That is one of the insolvency process. And FEMA has given order to ED to seize the asset. So definitely there is inconsistency of the FEMA provision with IBC. You agree? And
Yeah,
in this case, Calcutta High Court rightly said that because of the section 238, IBC will get the prominence, will get the supremacy. But if there is no, that's why I said that I discussed with you, sir, that they said that should be peacefully coexist. Definitely, the main idea should be that all the laws are framed by the government with some objective. So why unnecessary everything will be ordered by IBC provisions? No. Unless and until the activity is related to the insolvency process, unless and until there is a conflict of provisions with IBC, that's why our topic is interplay, interplay of IBC. Not always IBC will what should I say? Should affect the provisions of the other laws.
Okay.
But only in case of insolvency, definitely IBC will get the prominence, and that prominency will come as per section 1238 and also the moratorium provided in the Acts. Okay.
Okay.
sir.
Okay. Okay.
Yeah. The Calcutta High Court's ruling carries several positive implications for IBC framework, particularly in the corporate insolvency context, preserving the collective estate. Because you know the company now, what is the difference? Again, I'm telling you, sir, again and again, I'm telling you, IBC is not for recovery, only for resolution. So if you don't keep the assets as such of the corporate debtor, definitely it will be meaningless. It will not create any resolution for it. If the assets are going out from the hands of the corporate debtor on a peaceful basis, no one will be interested to take that company.
343 का अभी कैसा है यार? ये है क्या देखो?
Any question,
हाँ,
sir?
443.
May I
Capital
request
में
who is not
4CC
talking, can you please mute yourself, please?
4CC 888
888 एक ही बार है ना? 4CC 4CC 888.
Okay, 4CC 888 sub
Mr.
capital.
Praveen Navendra, can I request you please mute yourself? We are just end of our program. Can I request you kindly mute yourself?
वही ना बुक में एक्सपेंस आउट कर देंगे ना.
Mr. Navendra, can I request you please mute yourself? Preserving the collective estate, the judgment by enforcing the moratorium against FEMA proceedings, safeguarding the corporate debtors' estate from external attachment. This upholds the IBC's collective resolution model. All creditors share in the assets pooled by the insolvency process. If government agencies or creditors could seize assets during insolvency, it would weaken the, just see what I told you, that it would weaken the estate's value and disrupt the equitable distribution. So this is the main intention, main purpose of the legislator to keep that provision 232 within the code. The court's decision ensures that the assets earmarked for IBC or liquidation remain intact, maximize the returns for all stakeholders. Ensuring legislative consistency.
It is only for
हाँ.
proceedings, but when it is advantageous to the corporate debtor, I think we can proceed as per FEMA. Is it not?
Come again, sorry, I couldn't get you. Come again.
No, when we can realize something or when it is advantageous to the process, to the corporate debtor under CARP, we can always say FEMA applies.
No, madam, how can we say this? Because first of all, ma'am, one thing I'm telling you that
It's for
being an
proceedings
economic law,
against, I understand, proceedings against the corporate
no,
debtor.
not proceedings. You know what's happening? How can you say that it will be the advantage? Because if you see the objective of IBC, it is for the taking the interest of all the stakeholders.
Yes.
Even the corporate debtors, operational
Yes.
creditors are also a stakeholder. So
Yes,
if
for the
FEMA,
maximization of the assets, if it is advantageous, we can always take.
just give me an example. How if the ED
See,
takes
if
over
you-
the assets, if the ED takes over the assets of the Sri company, what is his name? So how it will be the advantage for the corporate debtor? Because it will go to
Point of
the regulator.
recovery. When
Huh?
it is a point of recovery, we
Huh?
can always
it's
say, yes, we are proceeding under FEMA. That is
No,
not allowed.
that's why I'm saying that what I tried to mention, that it is then inconsistent with the provision of IBC.
Okay.
Because the government regulatory, they are taking out the money, they are regulating the asset from the estate of the corporate debtor. It affects the objective of things. Suppose what's happened, the company is not within the CIP process. Definitely, the CD can take out the asset from the company. That's why if you've seen one of the observations also there, the order for liquidation was given in the year 2018, and ED has issued the notice in the year 2022 after the liquidation order. So once the liquidation order is, how can it be advantageous for the corporate debtor? if the government regulatory authority takes out the asset from the estate of the corporate debtor. Isn't it, ma'am? Yeah, ma'am. Hello, is it clear? The decision reaffirms Parliament's intent behind Section 238 of the Code and that the IBC will be exclusive court for insolvency, overriding prior statutes. Because we have seen the joint parliamentary report also. But from the very beginning, government wants it should override. Because this deals with the insolvency of the company, of the entity. The court, by holding the famous provision, must give way to the moratorium, avoids an untenable situation where different laws. You get your answer from this. Yeah, avoids an untenable situation where different laws pull a corporate debtor's asset in conflicting directions. Cannot be taking the interest of all stakeholders. This clarity prevents uncertainties about which law prevails. It is beneficial for insolvency professionals, creditors, and courts alike, and it is beneficial for the individual and courts alike. In practice, it means insolvency practitioners can proceed without fear that a parallel FEMA action might undo their work. Parallel activities from the other provisions of other acts is not permissible, it cannot be done. Promoting timely resolution, one of the IBC's core objective is time-bound
Madam.
insolvency resolution.
அர்ஜென்ட்டா
Hello?
உங்க சஜஷன் வேணும் மேடம். இப்போ
sorry?
இப்போ இது என்ன சொல்றது, டெக் ப்ரோல வந்து எக்ஸ்டென்ஷன் கொடுக்க மாட்டாங்க அப்படின்னு.
Madam, any question? Otherwise, mute yourself, please.
இதை சொல்லியாச்சு, அவங்க சொல்றாங்க இருக்கிற ஃபேக்ட சொல்லி பார்க்கலாம், ஆஃப்டர் ஆப்ஷன் போகலாம், இல்லைன்னா அப்புறம் பார்த்துக்கலாம் அப்படின்ட்டாங்க. அதுவும் வாங்கறதுக்கு ஒரு 50 லட்சத்துக்கு ஒரு ஆள் வந்துட்டான். 50 லட்சம் பத்தாதான் உங்களுக்கு ரெக்கவரி.
Ms. Alam, do you have any question? Otherwise, please.
இப்போ ரெண்டாவது வந்து என்னன்னா பப்ளிகேஷன் வந்து
Sir, I think the coordinator can mute everyone, sir.
Unmute somebody is unmute. Mute it, sir.
So I think coordinator can do it.
Please mute, yeah.
Disturbing the class.
Promoting time resolution, one of the IBC's core objectives is time-bound insolvency resolution, allowing external proceedings to continue, to prolong or derail the process. The judgment removes such disruption. For example, the liquidator could focus on selling of the business of Sri Ganesh or its assets without the specter of enforcement seizures. This predictably encourages investors and resolution applicants knowing that the statutory moratorium will be. Reinforcing the moratorium scope, the judgment explicitly extends the moratorium to FEMA actions. This is the main important thing, that moratorium thing should be honored by any statute operating in India. The board construction applying to regulated. Hello? The board construction applying to regulatory acts as well as judicial suits underscores the moratorium's wide sweep. It signals that all types of proceedings against the corporate debtor, either civil, criminal, quasi-criminal, or statutory, are suspended. For the IBC reason, this universality bolsters of moratorium as a robust shield during insolvency. Deterring forum shopping by holding the ED's actions where unauthorized, the court removes any temptation for creditors or authorities to evade the IBC process. Agencies cannot, for example, rely on earlier initiated cases under other laws to frustrate the court's purpose. This discourages forum shopping or
Excuse me, Satyadevi Alaram.
சொல்லு காரங்க சொல்லு.
Mrs. Satya Devi, please mute it and your voice. Hello, Satya Devi ma'am.
Yeah, yeah.
Please mute it.
Thank
You
you.
are there.
In effect, IBC becomes the forum of exclusive jurisdiction for everything touching the corporate debtors' property once proceedings have commenced. Balancing accountability, the court most importantly balanced the moratorium with accountability by allowing proceedings against individual officers to continue. This maintains the deterrent and penal aspects of FEMA without harming the corporate rescue or liquidation. In other words, the corporate debtor's property is protected by moratorium, while individuals cannot hide behind the corporate forum. This demarcation upholds the IBC's goals, preserving value while not avoiding other laws. Substantive breach. The Anup Kumar Singh judgment makes clear that during corporate insolvency under Part 2 of IBC, the court's moratorium stands supreme over any conflicting legislation, including FEMA. By quashing Iris Caesar's order, the Calcutta High Court has reinforced key insolvency principles, collective assets protection, time-bound resolution, and legislative intent behind the IBC. It enhances the coherence and efficacy of Indian insolvency regime by ensuring Part 2 of IBC operates undisturbed by extraneous legal provision. So I am through with my presentation. If you have any question, you can, I think, have 5 minutes.
So just one or two questions in case
Yeah,
we have
sure.
not, in case I missed out. So one
Yeah,
thing is
sure.
like under liquidation, when we proceed for distribution under Section 53, what is the final position with regard to PF dues and ESI dues? Because there are a lot of conflicting judgments. Are they to be provided for before commencing distribution under Section 53, or are they to be considered as part of Section 53? Because ESA and PF department, particularly PF department, have been always contesting, saying that they are outside Section 53. In the sense, their dues have to be provided for, then only the distribution can commence.
Yeah. Look, one thing I can tell you is a very good question. And really, I am also facing the same problem. If the corporate debtor, as per the recent jurisprudence, or as per the circle jurisprudence, I should say, if the corporate debtors maintains the retailer benefit funds, that fund will not constitute the liquidation estate.
Sorry, can you repeat it again, sir? If the corporate
If,
debtor?
if the corporate debtor has the retailer benefit fund, you know, many company creates the fund, either with themselves trustee fund or with LIC. That fund will not form part of the liquidation estate.
Okay.
You have to utilize the fund upfront. It will not cover under Section 53.
Fine, sir.
So you pay.
So I had a case where the fund is not there.
Let me.
Yes, sir. Yes, sir.
But you know what's happened in Jet Airways Kormachari case? Supreme Court say that, look, this retailer benefit is very essential for the employees or workmen. So you have to pay it. But again, I am telling you, it is the evolving one. It is for the particular case of JTRS. And again, I am telling you, it is for the CIRP process, not for liquidation. This is very important, sir. I take these things, they look, this is for the liquidation process. Supreme Court has not given any judgment. Or that particular Jet Kormacharis didn't proceed to Supreme Court and say that your order will also be applicable for the liquidation. So till now, according to me, again, it is my personal view, according to me, Supreme Court order for Jet Airways Kormachari only applicable for CIRP, not for liquidation. And so, as per Section 53, my opinion, if the fund is there, literal benefit fund is there, that will be utilized as such. Otherwise, it should be as per the provision of 53. I
Okay.
have written to PF accordingly. That you have this is the position.
Right, sir. Thank you, sir.
So let it be settled. Let it be settled. So any more question?
The same logic applies to ESI dues also, sir?
Yes, I do not. No, is there? No, jurisprudence is there. Yes, I will definitely govern under section 50.
Under 53 only.
53.
So ESI will be
gratuity.
it will be an operational creditor.
Yes, I mean government creditor as per that.
Correct.
He or it.
Okay.
But PF only for PF there is case laws or there is a judgment from the apex court.
Okay.
So that we have to be very careful.
Right.
So if fund is there, definitely you have to pay out of them. It will not be constituted as the liquidation estate. You have to pay. You have to utilize the fund fully for payment to the PF. So any more question?
One more point, sir.
Yeah.
In CARP and liquidation matters, we find that there are multiple agencies, particularly government agencies, who always have attachments in place. And when the CARP is commenced or when the liquidation is commenced, they don't remove the attachment. Then unnecessarily it has to be litigated and a long time consuming process happens in NCLT. And finally NCLT gives the order that the attachment is not valid, you have to remove it.
Yeah.
And lot of time gets but I think there is a Supreme Court judgment also which says on coming to knowledge of CARP, the statutory agency should remove the attachment so that this process can go on. But I don't know why, this every time, every case, whether it is GST department, whether it is PF department, they attach something and then that remains, and then you have to fight it out.
But sir, if you see, that's what I'm saying, it's a very evolving law. If you see the recent orders of JP Power, Jaiprakash Power and Energy, Supreme Court categorically said that if any attachment, any done by the GST or any government regulatory, you have to first write to that authority. If they refuse to take out the then you have to approach their appellate authority.
Achha.
So GST put the attachment, you first write to them, the assessing officer or the person concerned. Then if they don't, then you write to appellate. If the appellate authority also not listen to you, then you approach NCLT.
Sir, this is
Supreme
in
Court
which
say that NCLT doesn't have any power to directly order the government regulatory to take out the attachment.
This is in which case? This is which case law, sir?
I think this is Jaiprakash Power and Energy.
Okay, sir. Okay, sir.
But there is some review of this, but I think it is not done. So any more question?
No, sir.
So then we can stop our presentation. We can conclude our. Anyone from ICSI? Hello?
Yes, sir, I am here only.
Yeah, Anjali. Anjali, then can I conclude my session?
Sure, sir, we can conclude.
Okay. So I
Thank you
really
very much, sir. Thank you very much, sir, for taking out time and acting as a speaker for taking session on topic Interplay of IBC with FEMA Act. And sir, the session was very wonderful and interactive. Sir, it is requested to kindly please share the PPTs also.
And I really want to thank the participants. It is really a very interactive session, and really I like it. Very, very. Thank you so much.
Thank you, sir. Thank you very much.
Thank you.